Some lawyers can never finish anything. And the scary truth, guys, most lawyers don't have training on expert witnesses.
Why is that?
Because they haven't bought my book. No, I'm serious. It's hard.
It's frustrating.
Yeah. So, I mean, I hate to say it, but maybe, it's not an inconsequential expense, but I teach in my book how to do direct examination. I teach how to do cross-examination and reference the best materials out there for lawyers. But the best CLE for lawyers is usually going to be ABA Family Law Section or AAML. Well, you're only talking about 5% of the lawyers who are members of either one that go and get that training. Expert witness, direct examination and cross-examination and establishment reports and all that is not taught at the local level. I teach it. I've taught it in Memphis. And I'm telling you, you know what my attendance is like? 5 people. Yeah, I've spoken in front of 500 to 1,000 people at AICPA conferences and ACVA conferences, and I get 5 in Memphis. So what? Like it's going to hurt my feelings. But I'm just saying, people, the lawyers don't know what they don't know. It's very scary. Now, the good part is, odds are only a handful of lawyers are even going to know the right questions to ask. But that's what we train for, right? Is the lawyers, the A-list lawyers who know what to ask. All right. Oh, but also look at this as a double-edged sword. You train them, but bill for it. Here's how you do establishment phase of an expert witness. All right. I had a terrible moment, and it wasn't terrible. This is somewhat of a humble brag, I guess. But the first time I realized I didn't need to plan the direct examination of Rob Vance. I could do it. It didn't matter what the case is. I could take Rob through 20 minutes right now, cold. But I've been teaching it for 20 years. That's not really fair, because I don't even need to know what the report's about. Mr. Vance, what were you asked to do in this case? What did you do in the case? What documents did you review? Who did you talk to? Did you have an occasion to form an opinion? What is that opinion? Did you write it down? Your Honor, I'd like to move into evidence the report. Okay. All right. But it's 20 years of experience to get to that point where I could just rattle it off. All right. Now, there's 15 different evidentiary issues that I just glossed over, including all reports are hearsay. Even with the expert moving it into evidence. Why is it admitted even though it's hearsay?
I'd like to know the answer to that.
Must be those 3 letters.
Close, that's not bad. Well, the judges see that you put all this work into it and it becomes part of the record. So they're going to, you did the work, gotta move it in. It's hearsay. It's an out-of-court statement by the witness who's sitting right there, offered to prove the truth of the matter asserted. It's hearsay, but they let it in. That's the real world versus technical law. Okay. Again, another tip, especially if you're young, and yes, we consider you young. I know, just bear with it. Just wait 10 years from now, it's even going to be worse. It's not going to get any better from us old people. How do I know? I attended these things 20 years ago, and I got that speech from them. Now, But that's a great opportunity to share with the lawyer. Move the report into evidence. Okay? And the judge will most likely let it in. I've never had anybody excluded on the basis of hearsay. Not once. All right? But some people aren't readers, including judges, so you got to go over it from the stand. That's much more important.